You hear the words crime and accident thrown around all the time, but what is the actual legal line that separates a tragic event from a punishable offense? How do courts decide? Well, it turns out there's a surprisingly clear system for it, a kind of four-point checklist. So picture this. A brick falls from a building and tragically kills a person walking below. Is that just a horrible accident? Or did someone just commit a crime? The answer is, it totally depends. It all comes down to whether the situation ticks every single box on the law's very specific checklist.
And that's exactly what we're going to do right now. We're going to walk through this four-point checklist together. These are the essential ingredients that absolutely must be present for any act to be legally called a crime.
So, what's in this legal recipe? What are these four core ingredients that can turn a simple act into something criminal? Here they are. First, you gotta have a human being. Second, what the law calls a guilty mind. Third, a guilty act. And finally, there has to be some kind of injury. Now, here's the kicker. If even one of these is missing, then legally speaking, there is no crime. Let's break these down, starting with the one that seems, well, pretty obvious. It might seem obvious to us today, but it wasn't always. A little over 100 years ago, a circus elephant named Mary killed a handler who was reportedly mistreating her. And the town's response? It's chilling. They held a trial, found her guilty, and then publicly executed her by hanging her from an industrial crane.
That story is so shocking to us now because the law has evolved a ton since then. Today, the very first requirement for a crime is that the person responsible must be a human being. An animal can't form criminal intent. But get this, the legal definition of human being can also stretch to include what are called juridical persons, basically things like corporations, which can absolutely be held criminally responsible for their actions.
Okay, so we have our human actor. Now for the second, and you could argue the most critical ingredient. What was going on inside their head? The law has a great name for this, the guilty mind. The official legal term is mens rea. It's a Latin phrase that literally means guilty mind, and it's all about the mental state of the person doing the act. Did they mean to do it? Did they know what they were doing was wrong? This whole idea is captured in this foundational legal maxim. It basically says, an act does not make a person guilty unless the mind is also guilty. In other words, you can't just look at what someone did, you have to look at the intention behind it. A guilty act needs a guilty mind. So, who does the law say just can't form a guilty mind? Well, generally, this includes someone who's legally insane, a really young child, or someone who's acting under a genuine mistake of fact. You know, like if you accidentally grab someone's phone from a table thinking it's yours, you didn't have the dishonest intention, so it's not theft. And that brings us to our third ingredient, the actus reus, or the guilty act. This is the physical part of the crime. See, a guilty mind all by itself isn't enough. You can think about robbing a bank all day long, but until you actually do something to make that happen, you haven't committed a crime.
Now, the guilty act isn't always as simple as it sounds. For some crimes, like murder, the guilty act is the consequence, the person's death. If you shoot at someone and they survive, you can't be charged with murder because that final consequence didn't happen. But for other crimes, like perjury, that's lying under oath, the guilty act is the conduct itself. Just the act of lying is the crime, whether anybody actually believed you or not. So, let's recap. We've got a human, a guilty mind, and a guilty act. The final piece of the puzzle is an injury. But when the law says injury, it's thinking way beyond just physical harm. It could be harm to someone's mind, like through threats and intimidation. It could be harm to their reputation through defamation, or, of course, harm to their property, like theft or vandalism. Okay, so we've got our four ingredients: human, mind, act, injury. Simple, right? Well, you know, the law loves its exceptions, and there are some pretty big situations where that whole guilty mind rule gets tossed right out the window. This is called strict liability. So why on earth would the law just get rid of the guilty mind requirement? It really comes down to one thing: protecting the public. For certain offenses that are so dangerous to society as a whole, the act itself is enough to get a conviction. Your intention or your lack of it is totally irrelevant. What kind of offenses are we talking about here? Think about things with massive social consequences, huge environmental disasters, violations of food and drug safety, or even kidnapping.
In a lot of places, if you take a minor across state lines, it doesn't matter one bit if you genuinely thought they were an adult. The act itself is the crime. The law is sending a very clear message. When the stakes are this high, you are responsible for your actions, period. To really understand why this exists, you just have to look at the Bhopal gas tragedy in India. Back in 1984, a gas leak at a pesticide plant killed over 2,000 people almost instantly, and thousands more died in the years after. When you're faced with that kind of catastrophic negligence, the law can't get bogged down in proving one specific person's guilty mind. The immense harm to the public demands accountability for the act itself.
All right, now for our final, and maybe the most fascinating exception of all, a crime that can be punished at its absolute earliest stage when it's just a plan. This is the world of criminal conspiracy.
Now, I know I said earlier you can't be punished for just thinking about a crime, but what happens when you share that thought with somebody else and they say, yeah, let's do it? Can you be punished for an idea that 2 or more people share? In the wild world of criminal conspiracy, the answer is a shocking yes. The crime isn't the act, it's not even the preparation, it's the agreement. The second 2 or more people agree to commit an illegal act, the crime of conspiracy has already happened, whether they actually do anything else or not. But, of course, there's a crucial distinction here. For the really serious stuff, we're talking offenses like murder, the agreement alone is enough to get you punished. For other illegal acts, though, the law usually needs to see the agreement plus at least one small step, what they call an overt act, taken to move that plan forward. And what does the law even mean by a legal act? It's a really broad term. It includes actual criminal offenses, of course, but it also covers things that are just prohibited by law, like creating a public nuisance, or even committing a civil wrong, like trespassing on private property. An agreement to do any of those things can be a criminal conspiracy. So this brings us to the central puzzle of conspiracy law. It's designed to stop a shared guilty mind before it can cause any real harm. But it also raises a really tough question. When you're prosecuting an agreement made in secret, with very little physical evidence, how can you ever be sure what was truly in anyone's mind? It's exactly that question that makes this one of the most powerful, and maybe one of the most controversial, tools in the entire legal system.